Good evening. You and the Law is brought to you by the Chicago Bar Association. I'm Attorney Ed Snyder, a member of the Chicago Bar Association. On today's program, we're going to be discussing the crime of groping. In particular, we're talking about the nature of the crime, the the penalties for committing the crime, the prosecution of the crime, and perhaps also some civil litigation that might be associated with the crime. With me today is Attorney Daryl Goldberg, whose legal practice concentrates in the area of criminal law. Daryl, thank you for joining us today.
Sure, happy to be here.
So anyway, we're going to talk about the crime of groping and go into details of prosecution, defense, and even civil matters. All right, let's start out with, excuse me, Daryl. Let's start out, how is groping generally defined?
Generally, the traditional definition would be touching another's private parts, private area, often for sexual gratification. I think that's the way it's usually defined.
Okay. So, all right, so, all right, and so obviously it's a very specific definition. It's very clear either it happened or it didn't happen. So, is there any active crime, any actual crime of groping in Illinois?
Yeah, so on the books, so to speak, no.
Okay.
But there are a variety of different ways what most people think of as groping could be prosecuted.
Okay, yeah. That's
So
what I thought.
we can certainly talk about all of those.
Yeah, well, why don't we do that? Do you want to talk about them now, what they might?
Yeah, sure. So,
yeah. Why don't we talk about that?
So generally speaking, most groping crimes are going to be misdemeanor offenses.
Okay, that was going to be my next question is, you know, if somebody's going to be prosecuted for groping, what are going to be the particular criminal prosecution? So I guess
Right.
that's the direction we want to take.
So I can see ordinarily it could be a simple battery, which is a harmful or offensive touching, which is how it's generally defined. There's also some with injuries, but an ordinary one would be a garden variety battery, so to speak. There's also would be a disorderly conduct, which would be
Which is a separate
charge.
Separate
right.
charge, is that right?
Which would
Okay.
be like an unlawful act which would alarm, disturb, or breach the peace of another. So you could be prosecuted that way. And it could also be prosecuted as criminal sexual abuse, which sounds worse than the penalties are, but that's a misdemeanor. There's also a felony version that's somewhat similar, but that one is really sexual conduct by the use of force or threat of force. And there's also a different provision of that statute which would be nothing to do with groping, but if two minors were to engage in an act of sexual penetration, but one was 17 or under and then the other one was over 9, it's still a misdemeanor. So high school kids who have sex, it's basically a misdemeanor offense. That's another variation of the very same statute, which I could see, or another subsection where I could see groping being prosecuted.
I see. So, but if it was but assume it's just two adults situation, then that would be, what type of penalty would that be again?
So the battery, actually, a simple battery would be a Class A misdemeanor, which is punishable by up to 364 days in jail and a fine. And criminal sexual abuse is actually a Class B misdemeanor, which is up to 6 months in jail and fines. And disorderly conduct, there's different variations, but those are generally Class C misdemeanors, which are punishable by 30 days in jail and a fine. But then repeated offenses make it aggravated, even enhance it to a felony. There's so many variables that can take a garden variety misdemeanor like this, if it's between family members or with a teacher and a student, and you're going to get into felony category a little bit quicker.
I see. So, and now, if someone were to, you know, sort of repeat that,
Yes.
that aggressive activity against someone, not just the same person, but different people, and they're prosecuted, you know, once and then on a misdemeanor and then again, does the repetition of that crime cause a greater penalty?
Yes. So upon conviction, first offense, second offense, third offense, that's generally how it would move up. There's also felony prosecution. So if there is an act of penetration, which I think would be kind of rare, but if someone is groping and actually make penetration, it'd be a felony. Or if there's an injury, which I could see, I suppose, happening, or if there's a weapon involved, all of those things would make them felonies.
Okay.
But again, we're talking generally speaking, I think most of them would be misdemeanor offenses, and those are the ones that even make it to the light of day. I think a lot of people may be offended personally, but they might not, these things might not catch the eye of prosecutors or police or never even get reported.
All right. Well, let's talk about, I mean, now we sort of have an idea of what these potential penalties might be, punishments might be for that behavior. What about the potential defenses for somebody who's accused of the crime? How would they be?
So I think that one you would typically see is it did not happen, right? Or if it did happen, the person didn't mean to touch you that way. So like for example, the other day I'm walking in a crowded area and someone kind of rubbed up against me, probably inappropriately, but it could have just been because it was crowded. And that's the type of example where I don't think that people would push it and seek a prosecution, but you never know. If the right person's offended, they might go to the police and say, hey, this person touched me inappropriately, but I could see it being, it didn't happen. Or I could see it being, it happened, but it was consensual. That's something different. Or some people have motivations to lie. I think that comes across often in any prosecution where people are teeing something up for a civil lawsuit, or there's a workplace dispute, and this is the
workplace
way.
Might be a
or
issue,
or people think of, and it wouldn't happen in like a divorce context, but people think when people are going through a contentious litigation like a separation divorce, things always get thrown out there and people question whether it actually happened or not, and that's what the finder of fact might have to decide.
Okay, so, but I guess one key here is witnesses. Did somebody see it happen?
Right.
Or was it videotaped in some hallway or someplace like that?
Sure.
And so that, if that happens, then you have an evidence issue of, if you don't have that evidence, then it's just he said, she said.
He said, she said, and then of course it has to be proved beyond a reasonable doubt, and a lot of judges, I could see, this would, in my opinion, this would probably be a bench trial opposed to a jury trial.
Okay.
And
now, why do you say that? Why would it be a bench as opposed
I can just see that if it was, uncorroborated and it's he said, she said, it still has to be proved beyond a reasonable doubt. And if the defendant is credible, if they choose to testify, or for example, it could get reported many different ways by the complaining witness. Slight variations may be material impeachment. It depends on how it comes across or how it was written up in a report. And at the end of the day, the bottom line is it's hard for the state to meet their burden of proof on something like this, where the judge wasn't there, they don't know what happened, so tie goes to the runner, meaning the defendant. It's not proof beyond a reasonable doubt. Or another defense, while we're sort of on the topic, is, I might have touched someone, but it wouldn't meet the elements of the particular offense charged. So for example, this really shouldn't be so offensive to the ordinary person, or this is not a breach of the peace, or this really shouldn't cause anyone alarm. But I guess if we're talking on groping particularly, it's hard to think that, touching in a private area wouldn't cause someone a certain reaction. But I think you have to look first at how it's even brought into court, meaning what is the specific charge and what are the elements of that offense.
I see. Now, who actually, the judge makes a decision about whether or not there'll be a jury or not?
No, so the defendant has a right to a jury or a jury trial, right? Unless they waive that right. So in the state system, for example, it's the defendant's exclusive right. In the federal system, in order to have a bench trial or a trial before a judge, everyone has to agree, meaning the defendant asks for it, the prosecution would agree to it, and then the judge has to think it's the right decision also. But in state court, it's very common, a defendant comes to court on the day of trial after consulting with their attorney, and they say, I want to waive my right to a jury trial, sign a jury waiver, and the judge makes the decision.
So the defendant is much more likely, in his view, to get, or his view, is he more likely to have a better feeling that he's going to have a better outcome if it's just before the judge as opposed to the jury.
Yeah, well, for example, so there's certain things that might inflame a layperson, And
Yes,
and
yes.
so if you're on a jury, you might look at it one way, where if you're telling the judge, look, this is not the offense I'm charged with, put aside, any what I'm reaching for the word, but like look exactly at the crime charge. As an experienced jurist, you see it all. You're not going to get inflamed by the nature of the charge, and so you can render a fairer decision, if that makes sense. And so you just get right to it instead of putting it in the hands of someone who you have to kind of weed out past experiences in life that may make them jaded or have a particular bias against a defendant, and side with a complaining witness who's making an accusation like this.
I see. Now, in terms of the potential defenses, if someone has some psychopath, has a mental disorder, whether antisocial, significant antisocial personality disorder, and they're a psychopath, is there any sort of, is that a defense for prosecution, that if someone has a mental problem?
If it would meet the definition of insanity, right? If they can't appreciate what they're doing, their conduct, then sure, I suppose. I also would think that a lot of those cases, if let's just say a random person's walking down the street and they get accosted by somebody, but it's clear they might have some mental health issues, I don't know that it would make their way into the court system. And even if they did, I don't know that the person, if they were granted bail, for example, would show up on their next court date, and it might not get that far.
Yeah.
Or if they are locked up, maybe they would plead guilty to it rather than, take a mental health defense route, because the penalties really are not that severe on, on a first offense.
Yeah, and we'll revisit the potential criminal penalties again, because I think we need to sort of focus on those again. So let's suppose it's the common situation of a groping event, intentional, but not physically damaged or anything, but what would be the potential criminal penalties on that?
So I think again, depending on the statute, let's just assume we're talking about misdemeanors.
Okay.
Most times, if it's a first offense, someone will be given an opportunity for court supervision, which is not considered a conviction, but it may or may not be expungible or sealable, depending again on whether it's battery, disorderly conduct, or criminal sexual abuse. There's different ways. While it may stick around, it might be of record for some time, but I think that court supervision would be the first offense. Sometimes it would be a conviction or probation or conditional discharge, and criminal sexual abuse may also qualify someone for registration on the sex offender registry, which is considered a collateral consequence currently. But there is certainly something punitive. There's a real punishment, probably the greatest punishment of anything that we're talking about, if someone would have to register as a sex offender.
I see. Well, let's talk about the court supervision now. So if somebody touches somebody and they just go to court, and you're saying that it's a misdemeanor and they might get court supervision?
Yes.
How does that work? What happens?
Well, it's for a period of time, and in theory, you can either have reporting supervision or non-reporting supervision. But the easiest way to look at it, to simplify it, is you stay out of trouble for the period of supervision, and we don't have to revisit this.
Okay.
And if you do get arrested or commit another infraction, or if there's other conditions of your supervision, like staying away from the alleged victim, and then you violate that condition, then there's consequence.
Now, what's the term of the supervision usually?
Usually, I mean, it can be from 6 months. It can be from really a short number of months to 2 years.
Okay.
I mean, it can be some time. There's, you can be on probation for a number of years with a misdemeanor, but generally that's not going to be the case.
Okay, but you are. I mean, when you're under court supervision, the judge has found the person guilty of doing what?
Yes, or they admitted it.
They admitted it.
Yes.
Okay.
Right.
So they admitted it, and that's when they're supervision. But if they don't admit it and they're found guilty?
Yeah, if they're found guilty after a trial, same penalties.
Okay.
In theory, there's not supposed to be a tax or a penalty for exercising your right to trial.
Okay.
And they're eligible for the same disposition, the same punishment upon conviction.
I see. So you can be even if you went to trial, I mean,
and lost.
You'd
Same
still be
thing.
under court supervision.
Could be.
And could be, and that would be as a misdemeanor offense.
Right.
Okay. Would you have to have would the person have to be registered on that sexual offender?
It depends on the charge. So on criminal sexual abuse, I believe it's one of the qualifying offenses, but not a battery necessarily, and not disorderly conduct, no. And another way that a case might get resolved, if there's a closer issue as to whether there's criminal responsibility or not, or if the person has some other mitigating evidence that they might present to a prosecutor to exercise their discretion on how to resolve certain things, I could see it also be prosecuted as an assault opposed to an actual battery, an actual touching, more of like the complaining witness was in apprehension of receiving a battery but never actually did. Or an attempted crime where if someone looks like they're going to grope someone and the person is like backs away, I could see where it's an attempt. And it's a lesser class offense, usually one class down. And
but it is an offense.
It is an offense.
The assault is the feeling that somebody's going to attack you, but they don't actually touch you, but
right.
And that is a
reasonable apprehension of an imminent battery.
Battery. Okay. Even though the battery does not occur. It's the
right. It's exactly.
appreciation might happen. Okay, very interesting. Well, listen, let's go on to the next issue here, and that is potential civil litigation because of acts of groping. So what experience have you heard about in terms of civil litigation on these matters?
So there can be orders of protection. You can go into court and you can say, I want this person to stay away, like again, depending on context, every case is different, but there can be no stalking, no harassment, no acts of sexual abuse, depending on how it's brought under what particular statute, and there's different requirements for that, but obviously that could be one thing that could happen. There also can be civil lawsuits where you can be sued for the tort of battery, or you can probably be sued for intentional infliction of emotional distress, or some other civil tort, or a sexual battery. There's a lot of, I think the creativity, is the only limitation on how you could try to rectify or right the wrong in the civil system. But I think that there may be like employment issues that are real. So if it happens in the workplace or the people work together and it happens outside of work, maybe they can seek some relief from their employer and separate people. And the whole idea would be to do whatever you can to prevent it from happening again between these two parties.
Okay, and you had mentioned the order of protection, and that's issued by the court. How long do orders of protection? So that order the court would be telling the defendant you're not permitted to come any distance, close to this person, or not. You're not even, this person's never be able to see you again, or how does it go?
So ordinarily, and again, I might not have this exactly right because it depends on the statute it's brought under.
Okay.
But they have you can get an emergency order where you can go, just the complaining witness goes into court, fills out paperwork, and petitions the judge for this emergency relief. And then they get an emergency order of protection that has to be served on the respondent, which would be like a defendant in a criminal case, but the respondent in a civil action. And they will have an opportunity to agree to certain terms, like staying away, or they can have a hearing to say it's inappropriate. And at the end of the hearing, it's usually if you get a plenary order, it's valid for 2 years. And those things are issued. They're in a database, which never really get expunged. There's not a mechanism to expunge them, so usually that can have some effect down the road if you have an interaction with law enforcement and they see, for example, an order of protection in your background. I would suspect you might be treated a little bit differently when you have your next encounter with the law.
I see. And that order of protection could be for 2 years?
2 years, yeah.
That's very interesting. Okay. Well, how often are individuals prosecuted for accusations of groping?
I think it's generally rare because I think most people's tolerance for, inappropriate touching where, maybe the damages are not physical but a little more psychological, emotional, they might let it go to some extent. And I think the ones that press forward for prosecution, there's so many reasons why it might either not make its way into court, or if it does, they resolve quickly, and you might not hear about a high-profile misdemeanor or groping prosecution. So I think it's generally rare.
The prosecutions then, I mean, it is rare, but it does happen, and usually is just a matter of a misdemeanor situation.
Yes.
Yeah, that's interesting. Okay. Now, crimes have statutes of limitations.
Yes.
So let's talk about what are the statute of limitations with respect to these types of crimes?
So generally speaking, it depends on the charge, again, and it's very specific, as a matter of fact. But in Illinois, there is an ordinary statute of limitations for a felony offense is 3 years, and an ordinary statute is 6 months for a misdemeanor.
Oh, 6 months for a misdemeanor.
So they really ought to be brought quickly if they're going to be prosecuted at all. But there's ways to extend it. When you're dealing with sexual conduct, statute of limitations can toll. When you're dealing with minors, a lot of the offenses, again, depending on the subsections that are being prosecuted, they might not be until the minor meets majority, till they're 18. And then it begins to run again, or there's so many ways to get around that, if you will. And I'm assuming that the civil statute for a garden variety battery is probably 2 years, but I'm a criminal defense lawyer, and don't hold me to that. I think there's a lot of ways around it.
Okay. Now, one of the things that sort of popped in my mind when I started looking into this matter was we had talked about the state of Illinois crime activity and statutes and statute of limitations, but one thing that sort of popped in my mind, if two people are traveling on a train, for example, and it's going to different states, or they're on a plane and it's flying over different states, which law is going to, and the train comes to a stop, or the plane lands, and the party's been abused, wants to report it. What state law is going to apply, or is there going to be a federal law apply?
I think it's both. I think there's two kings in this country. There's two sovereigns, so I think they would have a choice of how to prosecute it. I've seen it done both ways. I recall one where, there's some that they have exclusive federal jurisdiction when I forgot if you're in the air, or I forgot how it works, but a lot of disturbances happen while you're on the ground. I think those are the ones that are more commonly prosecuted in state court. And then I vaguely recall there was one federal prosecution a few years back where one passenger was accused of rubbing the leg of a younger girl next to him, and he ultimately was acquitted in a bench trial, which was, again, a little unorthodox for the federal system to actually have bench trials. Are not that common, but I remember he was acquitted.
And that was that'd be under federal law.
Prosecuted in federal court.
Would the same thing apply for a train?
Yeah, I don't see why. Well, if they're not in the air, I'm not sure. But if you're crossing state lines, the venue could probably be, that it's going to be up in there when it started, when it finished, and again, how it's actually prosecuted, or how many times it's repeated contact in one state versus the other. There's too many variables to discuss in our program.
No, I appreciate that. And I thought that might be the situation. It's one of these situations, it just depends where you are and where you're
Yeah, I think so too.
Well, listen, I think we've done a nice, interesting job discussing the various criminal issues associated with the act of that we're talking about, groping. And I want to thank you, Daryl Goldberg, for giving some very interesting information concerning the criminal activities and criminal matters concerning the act of groping. And I also want to thank you for watching this program brought to you by the Chicago Bar Association. If you wish to consult with an attorney concerning some of the legal matters we've talked about today, you may contact the Chicago Bar Association's Attorney Referral Service, who can provide the names and contact information of attorneys who are members of the Chicago Bar Association and practice law in various areas, including criminal law. Thank you for watching, and have a pleasant evening.